Hello and welcome back to our channel everyone. Today we will discuss all the previous year questions of All India Bar Examination क्योंकि अगर आपको ये previous year questions आते होंगे तो फिर आप आराम से पास हो जाएंगे क्योंकि हर साल काफ़ी questions directly या indirectly repeat होते ही हैं, इसलिए ये questions तो आपको पता होने ही चाहिए। लेकिन MCQs बहुत हैं और उन्हें देखने में टाइम भी बहुत लगता है, इसलिए हम यहाँ उन्हीं MCQs को वन लाइनर फॉर्म में प्रस्तुत कर रहे हैं जिससे आपका समय भी बचे और याद करना भी आसान हो। इस सीरीज में हम एक एक करके सिलेबस के सभी सब्जेक्ट्स के वन लाइनर्स आपको प्रोवाइड कराएंगे और आज के वीडियो में हम इंडियन एविडेंस एक्ट के अब तक के ऑल इंडिया बार एग्जामिनेशन में आए सभी क्वेश्चंस को देखेंगे। तो चलिए शुरू करते हैं। Whatever said by A or B a day before the day of beating is not considered as relevant fact forming part of the same transaction as per Indian Evidence Act. Section 25 of Indian Evidence Act says that confession to a police officer shall not be proved against him. Under Section 32, a dying declaration may be admitted as evidence. Contents of document may be proved either by primary or by secondary evidence according to Evidence Act. Leading questions may be asked in cross-examination as per the Evidence Act. Supreme Court of India clarified admissibility of electronic record as evidence in Anwar PV versus PK Bashir. Admissions are not conclusive as to matters admitted in light of Indian Evidence Act. Section 32(1) of Indian Evidence Act is an exception to the hearsay rule. Doctrine of res geste is discussed in Section 6. An admission made by a stranger in respect of his liability shall be an admission on part of that person who is a party to the suit under Section 19 of Evidence Act. Judicial evidence means evidence received by courts in proof or disproof of facts. Presumptions as to dowry deaths is given in 113B. Copies not certified under Section 63 are not secondary evidence as per Section 63 of Evidence Act. A leading question may be asked in cross-examination. Extrajudicial confession means confessions made either to police or person other than judges and magistrates. If someone lies before the court on affidavit, a perjury application can be filed by the advocates. Res ipsa loquitur means things speak for itself. Admissions are defined in Section 17 of Evidence Act. All admissions regarding robbery, participation and property as stated by the accused are not admissible under Section 25. Admission can be broadly categorized into judicial and extrajudicial. Evidence Act came into force on 1st September 1872. Under Evidence Act Section 115, a person cannot deny their own previous conduct if it was intended to lead another to believe in a certain state of affairs. The fact that A asked C to lend him money, D is advised to C not to trust A for owing B 10,000 and A going away without making any answer are relevant under the Evidence Act. A ने C से पैसे उधार मांगे तो D ने C को एडवाइस किया कि भाई A पे भरोसा मत करना क्योंकि A उसे भी 10,000 ओ करता है। ये सुन के A वहां से चला गया। This is relevant under the Indian Evidence Act. Information relating to the fact discovered by police may be proved under Section 27. When court has to form an opinion upon a point of foreign law, science, art, or as to identity of handwriting or finger impressions, opinions of especially skilled persons are relevant facts under Section 45. Res geste means relevancy of facts forming part of same transaction is dealt under Section 6. The occurrence of fact forming part of general transaction when A is accused of waging war is relevant under Section 6. Section 110 of Evidence Act deals with burden of proof as to ownership. 113A deals with presumption as to abetment of suicide by a married woman. Confession by one co-accused implicating other co-accused would be proved. In Kashmira Singh vs. State of MP, it is a leading case on confession of co-accused. Attempt is not relevant in civil and criminal cases under Section 8. If it is proved that a man has not been heard for 7 years by those who would naturally have heard of him, the presumption under Section 108 is that he is dead. A dumb witness giving his evidence in writing in open court would be treated as oral evidence. Character of a person is not relevant in civil cases to prove conduct imputed. A document produced for inspection of the court is a primary evidence. Accomplice is a competent witness under section 133. In section 118, a person is a competent witness if capable of understanding questions and giving rational answers irrespective of age. Judgment of criminal court is irrelevant under section 43 of Evidence Act. A witness has a right to refresh his memory under 159. Dumb witness giving evidence in writing in open court is treated as oral evidence. Arbitrators are not courts under the Evidence Act. Questions suggesting the expected answer is called a leading question. Lunatic who cannot understand the questions or is extremely old person who cannot give rational answers and is a tender age person who cannot give rational answers are all prevented from being testified under section 118. Any confessional statement by accused given to magistrate is admissible. In civil cases, Evidence Act bestows the burden of proof on the petitioner. Evidence Act was enacted in 1872. A dying declaration must be made by the deceased before death. Proving handwriting is provided in Evidence Act by the opinion of experts and by evidence of a person acquainted with handwriting. Section 26 provides that no confession made by a person in police custody is admissible unless made in the immediate presence of a magistrate. Evidence means and includes oral evidence, documentary evidence, and electronic records produced for inspection of court. Court includes all judges and magistrates. Admissibility of contents of electronic records may be proved in accordance with section 65B. Documents and correspondence from advocate and notary office are not considered public records as per provisions of Evidence Act. Section 18. In section 8, admission of one of the defendants is not admissible against the other. Section 6 is based on the English doctrine of res geste. There is no limit to the number of witnesses which can be produced in the case. Section 112 of Evidence Act provides that a child would be treated as legitimate if after dissolution of marriage he or she has been born within 280 days. In Kashmira Singh state of MP, the evidentiary value of confession of co-accused affecting himself and others was discussed. Evidence Act applies to judicial proceedings in court. Fact and issue means a fact existence or non-existence of which is disputed by the parties. Necessity rule as to admissibility of evidence applies when the maker of statement is dead, incapable of giving evidence or cannot be found, or unavailable without unreasonable delay or expense. Secondary evidence of a document includes copies and oral accounts of the document's contents. A will is required to be proved by calling at least one attesting witness regardless of his registration status. Any person in 106 refers to a party to suit. Pre-summoning evidence may be dispensed with if the complaint is made in writing by a public servant. Retracted confession cannot be solely made on the basis of conviction unless corroborated. A confession is inadmissible under section 25 if it relates to same crime for which the offender is charged. An unjustified delay in recording a material witness's statement renders evidence unreliable. Presumption of continuance of life is contained in section 107. Estoppel is a rule by which a party to litigation is stopped from asserting or denying a fact. Testimony of a witness to the existence or non-existence of fact or fact in issue is a direct evidence. A sees B running away from a room and afterwards sees C lying down in a pool of blood in the same room. A's evidence as far as seeing B running away is direct, but as far as the murder is concerned, it is circumstantial evidence. A ने B को एक रूम से भागते हुए देखा. जैसे ही वो रूम के अंदर गया उसने देखा कि C खून में पड़ा हुआ है. तो A का एविडेंस कि उसने B को कमरे से भागते हुए देखा, ये तो डायरेक्ट एविडेंस है, लेकिन कि मर्डर किया है C का B ने, ये circumstantial evidence होगा. A statement made by an accused before the trial begins by which he admits to have committed the offense but which he repudiates at trial is known as retracted confession. उसने ट्रायल शुरू होने से पहले बोला कि उसने ऑफेंस किया है, लेकिन ट्रायल शुरू होने पे उसने बोला कि उसने ऑफेंस नहीं किया है. This is a retracted confession. Expert opinion under section 45 is supportive and corroborative in nature. Section 122 A communication made to the spouse during marriage remains privileged communication after dissolution of marriage by divorce or death. Evidence to document unmeaning in reference to existing facts is called as latent ambiguity. Exception to the rule that the original document is the best evidence is contained in Banker's book Evidence Act. Nemo moriturus presumitur mentire means dying man can never speak a falsehood. Presumption of law is mandatory and irrefutable. In Salvi's case, Supreme Court of India examined the constitutionality of tests like narco-analysis, polygraph, and brain mapping on the touchstone of Article 23 and Article 21. According to Law Commission of India's 69th report, Section 27 is based on the doctrine of confirmation. Section 99 is based on the principle pacta tertis nec nocent nec prosunt. Burden of proving that a person is alive who has not been heard of for 7 years is on the one who affirms it. Court's discretion to permit leading questions is confined only to matters which are introductory facts, undisputed facts, and facts already sufficiently proved to the satisfaction of the court. The marks on the ground produced by a struggle at or near the place where murder was committed are relevant facts under Section 7. Section 93 of the Indian Evidence Act treats patent ambiguity as incurable. Section 45 and 46 of Evidence Act deals with relevancy of the opinion of experts. Content of documents may be proved either by primary evidence or by secondary evidence. Oral accounts of contents of document given by some person who has himself seen it is a secondary evidence. Principle that DNA test cannot rebut the conclusive presumption envisaged under Section 12 of Indian Evidence Act was held in Sheikh Fakhruddin versus Sheikh Muhammad Hassan in 2006. Witnesses are the eyes and ears of justice is a statement by Bentham. An accomplice is unworthy of credit unless he is corroborated in material particulars, which is presumption of fact. Patent ambiguity in interpreting documents renders it incurable. Facts regarding statements without related conduct are irrelevant under the Evidence Act. Test of competency of witness is their capability of understanding the nature of questions and giving rational answers. Dying declaration is an exception to the rule of hearsay. Communication between husband and wife is privileged and if made during marriage, even without a promise of confidentiality. Leading questions can be asked without court's permission during cross-examination. Evidence means facts introduced in a court of law. Fact in issue refers to necessary facts to determine rights, liability, or immunity. Relevant fact refers to facts legally relevant to any fact in issue. So with this, we have done all the questions of Indian Evidence Act which have ever come in All India Bar Examination. अगर आपको ये वीडियो अच्छा लगा तो वीडियो को लाइक करें, चैनल को सब्सक्राइब करें. अगर पसंद नहीं आया तो मत करिएगा. थैंक यू फॉर वॉचिंग. आई विल सी यू नेक्स्ट टाइम.